and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Thank you, Charlie. Okay, good morning. Welcome to another session of oral argument here at the 5th DCA. As our marshal, Charlie Crawford, just indicated, I am Judge Lambert, so I'll be presiding today. Let me introduce the panel for you. To my right is Judge Bruce Jacobus. Judge Jacobus is a senior judge. He's helping us out while we're waiting for an appointment to fill Judge Berger's spot, who was recently anointed to the federal court, Middle District. So Judge Jacobus has been appointed to help us out, and we appreciate that. He's been watching Perry Mason and Matlock reruns to make sure he stays current.
They moved my picture, too, back. Why is that? I don't know what happened, really.
No comment. That was an internal decision. To my left and to your right is Judge Elizabeth Starr. She is an associate judge seated with us, I think, for the first time. She is a county judge in Orange County judge, so she is sitting for Judge Grosshands today. She's applying for Judge Berger's spot. I think she had her interview yesterday, so we wish her luck with how that all went. I guess we'll find out today who made the cut. We have 3 cases on our docket today. Each side will have 20 minutes. I will set 5 minutes for the appellant for rebuttal. Tell me if you want something less or more than that. Just so we're abundantly clear in light of our argument last Tuesday, 20 minutes is your total. That's not 20 plus rebuttal time. Apparently one of our attorneys misunderstood that. But that being said, so tell me how much rebuttal time you want. Also, if anybody in the audience or any of the attorneys has an electronic device, laptop or phone or what have you, or anybody on the panel apparently, please turn that off or put it in the mute state so we can not interfere with the attorneys when they're arguing. Okay, first case on our docket. Excuse me. 18-467, Louise Toledo v. State of Florida. So, counsel, whenever you're ready.
May it please the court. My name is Jeffrey Dean. I represented Louis Toledo at trial, and I'm here for his oral argument this morning. Your Honor, I'd like to reserve half my time for rebuttal, if you don't mind. 10 minutes? Yes, sir.
Okay, let me.
I'd also like to apologize in advance a little bit. I'm a trial lawyer, and sometimes I'm a little plain-spoken, and I've been told I speak pretty loudly sometimes, so I just want to try to head that off.
If you're too loud, we'll let you know. And
appreciate that. Thank you.
Appreciate the heads up.
Can't hear, so that's good, really.
So I'll just say I'm speaking to Judge Jacobus if I get too loud. The case that we have in front of the court today has a few issues. The main issues have to do with a series of interviews that occurred right at the beginning of the case, in which Mr. Toledo began with his arrest on October 23rd at his residence that was in Deltona, Florida. He was put under arrest by a Lake Mary Municipal Police Department officer. Lake Mary is in Seminole County, and it's a small city inside Seminole County. She came down at the request of the Volusia County Sheriff's Office to arrest Mr. Toledo for an incident that occurred the day before on the 22nd of October in Lake Mary, Florida. When she arrived in her Lake Mary patrol car. She arrived in full uniform. She arrived armed and ready to place him under arrest. She was escorted into Mr. Toledo's residence with one of the Volusia County Sheriff's detectives that was there investigating a missing persons case that later resulted in murder charges against Mr. Toledo.
So what should have happened? The Volusia County Sheriff should have arrested him and then taken him to have him transported to Lake Mary?
Well, that's what the arrest statute says, and there is no authority, and this court has said so in case Gilbert versus the state. This court has said that the Gilbert case dealt directly with a search warrant that said any officer could serve the search warrant, but this court, the 5th DCA, has said that they had to interpret that statute strictly, and that what that meant is that any officer that was qualified to do it could serve the search warrant, even if somebody there was legally able to do it. That's exactly what happened here. She didn't have the authority. She arrived under color of law. She arrested him under color of law. There was no exception under the arrest statute that permitted her to arrest him.
That's your main concern here today?
Well, that's the first one. So he got arrested under that. He was transported to the Volusia County Jail. He was then taken by the Volusia County detectives to the Sheriff's Department, placed in an interview room. He was under arrest for the incident in Lake Mary. They immediately told him, he was there voluntarily, that they were not going to ask him about anything that had to do with the Lake Mary incident, and that they were concerned about the missing persons case, which was a very new case at this point. At that point, for the next 2 hours, they began to ask him questions, all of it related to the Lake Mary case, every drop of it, from how he had managed to put bugging devices on the phone of his wife, how he found out she was having an affair, what happened in the incident in Lake Mary specifically, and what he did and what she did. He went through the whole incident at Lake Mary. As they're asking him questions at this first interview, they are also investigating this case. They have found a neighbor who is now supplying them direct evidence about what happened. They now begin to confront him, literally, with evidence in the case. They ask him questions like, are we going to find your family alive? Are we going to, did you do anything you regret? What?
Can I stop you just for a second?
Yes.
Weren't there multiple interviews?
This is the first one.
So are you saying that in the first interview,
Yes.
they had already started to confront Mr. Toledo?
Yes.
Can you point to the record?
Yes.
And show us where?
Yes. In the interview, he was asked, sorry. He was asked these questions.
Exactly when? Was it that morning?
No, he's in the sheriff's office. He's been arrested. They brought him over. This is October 23rd, the first interview. So within 2 hours, they've begun to, they first asked him all about Lake Mary. They asked him a series of questions because they were being supplied information. At one point, they told him they found the car. There is a long confrontation between him and the detective named Sheps, who confronts him literally about if he had done anything he's sorry for, should they know anything. They asked him directly, are we going to find your family alive? We have found the car. We have someone that's put you there. He was also told that, that we have found somebody that's put you there, and also that they wanted to know if he did anything that he would regret. The witness that came forward was his neighbor and said that he had driven back with Mr. Toledo after placing the car back in Lake Mary, and he had delivered the car with him. And when he was in the car with Mr. Toledo coming back, Mr. Toledo had said to him that he snapped. In that interview, Your Honor, he said, he was asked directly, why would you snap? He was being confronted directly with evidence that had to do with the crime at that time. And they never read him his Miranda warnings. They said he was there voluntarily. They have literally questioned him about what he's in custody for at the time, and now they have turned that voluntary interrogation into a confrontation literally of the evidence that's there. The next day, they interviewed him again on October 24th. They brought him in again and said that he was there voluntarily. They admitted at the hearing of the suppression hearing that it was not voluntary at all. They didn't really even consider that. One of the detectives didn't even remember telling him that. After 16 minutes in the second interview, they then administered Miranda warnings because he was about to talk. He had actually said, I want to talk to you. They gave him his Miranda warnings, and at that point asked him, will you speak to us? He said, I want to talk to you, but you can get me one down here, can't you? Meaning he wanted a lawyer. Now, I understand the law on that, so at the suppression hearing, I asked the two detectives that were involved multiple times, you knew he wanted a lawyer at that moment, didn't you? They each replied in the affirmative without any equivocation. One of them,
Can I stop you again?
Yes.
Weren't some of the statements suppressed by the trial judge?
The only thing that was suppressed was the first 16 minutes of the second interview. Really, there was not much in there. He was being confronted at that point, and so that's when the judge thought, since he was being confronted, and the judge distinguished the first two interviews. The trial judge said, this is different than the first time he's being confronted. He was actually being confronted in the first interview. But the judge determined that he was actually being confronted and he should have been read his Miranda warnings when he got there.
So you agree with the trial judge's suppression of that? You just believe that it should have been extended earlier?
I believe he should have gotten him the first minute he went in on October 23rd after he'd been arrested illegally by the Lake Mary Police Department. If you don't believe that, then the trial judge's logic was he was being confronted the second day. He should have been read his Miranda warnings when he began to be confronted. But he was confronted in the first interview. So even under the judge's logic, he should have been read his Miranda warnings sometime in the first interview. He never was. That should all be suppressed. The second thing that happened is that he asked for a lawyer. One of the detectives, I said, you knew he asked for a lawyer. The detective looked at me and went, absolutely, I knew. The second detective said, yes, sir, I knew. When he asked for a lawyer in the second interview, he was literally told no. He said, you can get me one here, right? And they went, no, we don't have time for that. Now, they said that it was their policy not to provide a lawyer. That's fine. Maybe that's their policy, but it can't be their policy to continue questioning him. They never stopped questioning him. The judge then made a ruling in the suppression hearing because right after they told him, no, you can't have a lawyer, this was the first opportunity he had to invoke his rights, and he did. Once they told him that you can't have a lawyer, they continued to question him, and there was no break. Now, there's a lot of case law that says, Moss being one of them, cited in our brief, there's a lot of case law that says you don't waive your rights when you've invoked your rights and they continue to question you. That's not a waiver of rights because you end up answering the questions when you asked for a lawyer and didn't get one. That case law and that authority is in the brief. And, Your Honors, I wrote a very extensive brief that's part of the record in this case that outlined with transcript, quotes, and case law that's part of the record that was way too long to include in a 50-page brief and way too long for me to recite to you in a 20-minute argument. But I refer you to it. It's unambiguous he asked for a lawyer. He was denied a lawyer. They continued to question him. Then he went on and confessed. These confessions were the highlight of the trial. There's no question about it. They played those tapes for 2 days. They watched him do everything. The subsequent interviews should all be suppressed under Maryland versus Schatzer and Edwards versus Arizona because he invoked his rights. He was not given the lawyer he asked for. Every subsequent questioning after that is suppressed, even if he's given his Miranda warnings at that point. We believe that all of those should be suppressed. After he was...
Just so you're clear, you're under your rebuttal time now.
I see it.
You can keep going as long as you want. But
I understand. Thank you. I just wanted to mention that this is implicated in the issue of the corpus delicti we have. The whole case has to be proven, at least the elements have to be addressed of the crime charged. I've maintained all the way through this that while the state could prove death, they could not prove first-degree murder. There's no way that they could do that. I don't think they could meet corpus delicti, which is one of the elements of the crime charged, which is what they have to show before his statements would be allowed. That's our position as it is to corpus delicti, so I want to reserve the rest of my time. Thank you, Your Honor.
Okay.
May it please the court, counsel, good morning. Kelly Nealon on behalf of the state of Florida. With regards to the question that was asked earlier, he was confronted with the car evidence at page 1603 in the trial record, and that was approximately 2 hours and 17 minutes into the interview. Shortly after that, he said he was tired and wanted to go. They said, we just have a few more things to ask you, and they cleared that up, and they took him back to the jail. When they did find additional evidence after that, they went back to the jail and said they wanted to talk to him again, and he said, no, I'm too tired, come back later, and I will talk to you then. So it's our position, and that interview started out, I've lost my notes. Investigator Pagliari started out, okay, I want to lay it out here and tell you this, that this is a totally voluntary type thing for you, okay? I'm not going to talk anything about what happened in Seminole County. I have nothing to do with that. This is strictly a missing persons investigation. If you don't want to talk to me, you're free to go. I will take you back to the jail. Then the process will begin and whatever Seminole County has on you. But I want to talk to you. And we must also keep in mind that Mr. Toledo is extremely experienced with the criminal justice system.
Well, let me ask this. Forget about the October 23. October 24, I don't necessarily think it was an unequivocal request for counsel, but his argument is that the police officers understood it to be one, and they ignored it and they continued forward questioning after they believed that he wanted counsel. Isn't that problematic for you?
I don't think it is. I don't think their testimony at the hearing supports that argument. They said, yes, he asked us to get him a lawyer. We do not provide lawyers for suspects. The question that Mr. Toledo said, is there any way that you can get one down here just so I can run it down to him
Right,
first?
I agree with that. I mean, and that to me, it's pretty easy to say, I'm not going to talk, I want to see my lawyer. That his statement, Mr. Toledo, is not, it's equivocal.
Yes.
But my question, though, is if the officers believe that he is asking to have a lawyer here present now, and they ignored that, isn't that then problematic under Miranda?
The officers testified that they thought he was asking if they would get him a lawyer. All Mr. Toledo had to say was, I want to get a lawyer down here. Like I said, he's very experienced in the criminal justice system. He's clearly aware of his rights, and after Sergeant Sheps told him that he couldn't do that, he said, so if you want to talk to us and continue to help us find him, that's your option, okay? In other words, you can go right now, or you can sit here and talk to us.
Can I stop you for a second?
Sure.
And just, is it possible for this little snapshot in time, if you could paint us a better picture of what was happening, what Mr. Toledo's relationship was with these detectives? Did he know them before? From the record, can you tell me what were the surrounding circumstances on October 24th that led up to this, right before this question of, you think you could get me a lawyer down here to run it by, let me run it by him first? And then if you could just tell me what Mr. Toledo does after, in that short period of time.
That's in the record on this. I mean, it's not apparent within the first, 2 minutes of this, or I think it was 16 minutes when they read him his rights. But it's apparent from the record that he was extremely familiar with Sergeant Sheps. Sergeant Sheps had been the gang investigator in Deltona, and Mr. Toledo was a member of the Latin Kings. Mr. Toledo testified, he turned state's evidence, became an informant.
But you're citing this from the record?
There is, at one point in the trial, and I don't have the page number, but there was a motion in limine where they specifically discussed bringing out, what could be brought out about his former relationship with Mr. Toledo, and everybody was really, kind of backing off to avoid that topic so that it wouldn't, taint the jury, and the jury wouldn't be thinking, oh, how does he know him? But, I mean, it was apparent to everyone involved at this suppression hearing that he was very familiar with Sergeant Sheps. And again, from that same investigation, Toledo called the prosecutor from the Office of Statewide Prosecution in Orlando, Ann McMillan, and sat down and chatted with her for a couple hours and confessed to everything. She started out, you know you have a right to a lawyer. He said, I don't want to talk to my lawyers anymore. My lawyers told me not to talk to you. On at least 2 of the interviews.
What day was that interview on?
That one was not admitted at trial, but it was on October 28th. And on the first page of my statement of facts, I set out the transcript, or the record pages for all the different interviews. Before that, on the 26th, he asked to go, he asked the correctional officer to tell, he said Officer Curtis, which I'm assuming was Officer Kurt Sheps, told him to check the gator pits. Then he gets there, he says, Petey told me not to talk to you. That's at page 1876. Sheps read him his rights again, and they started talking about the gator pits. They went off the tape because Toledo didn't want to be on the tape, and Sheps said that That's when Toledo said, why don't you take me back to the house? You can loosen the handcuffs, and I'll pretend that I'm going to go for you, and you can kill me. I want to die where my family died. And that was the same interview where he said, I'm never going to tell you where the bodies are. And again, that interview on the 26th was done at his request, and he said that his lawyer said not to talk to them. He said the same thing to Ann McMillan on the 28th, and the interview with Officer Mejias on November the 3rd was also done at Toledo's request. He agreed within the interview that he had reached out to them. He was re-Mirandized for like the 7th time, and again waived his rights.
How many times did he ask to speak with the detectives? Or with statewide prosecution?
I have it on the 26th, the 28th, and the November 3rd. And as far as the,
What about his October 25 interview? Did he indicate that he wanted to invoke his right to remain silent? I don't want to talk to nobody no more, because nobody believe me?
I think in terms of, I don't think that was an invocation of his Fifth Amendment right to remain silent. I think that was just, I'm tired of this, I'm tired of talking, but then all of a sudden he started wanting to talk to everybody.
His answer was in response to a question from the investigator Pagliari about where are the bodies,
Right.
in essence, and he said, which is why I don't want to talk to nobody no more, because I don't know, and don't nobody believe me. I mean, isn't that him saying, I don't want to talk anymore? I mean, I understand he doesn't say, I'm now going to recite my Fifth Amendment right to, I get all that, but
Right.
he's saying, I don't want to talk anymore. But they kept talking to him, and he talks some more, and how is that not concerning from a Fifth Amendment standpoint?
Well, I think even if that was concerning, the only parts of that statement that were admitted into trial were that he drove over the bridge and took off his clothes and threw them into the water. And
That's incriminating. I mean,
but it was
that's
also-
usually we don't do things like that unless we have some reason to do that. That might be
but he
because the clothing is
also,
harmful to his position.
oh, that he went to his brother's house too. And his brother testified that he went to his house. And I believe in the November 3rd statement, he also said that when he was driving back, he took off his clothes and threw them over the bridge.
That's part of my question here is, I mean, I know Mr. Dean makes some important points here, but it seems like this fellow is testifying or talking to police on multiple occasions after Miranda, and he keeps providing similar inculpatory information. So isn't there a harmless error analysis with Fifth Amendment issues as well?
Yes, and also, I mean, when he reinitiated.
I mean, if you have a bad statement during one interview and then he says the same thing the next 3 interviews post Miranda, and he says, I don't want to talk, I don't want my lawyer here, et cetera, then, okay, maybe the judge should have excluded one of them, but certainly the point was gotten across in the state's case in chief about what Mr. Toledo is telling people post Miranda, I guess.
Correct, and that's essentially what the trial court found here, was that he was Mirandized, I believe, on at least 7 occasions, and he asked on at least 3 occasions to speak with the police. So, and the later statements that came in were cumulative to what he said on the 24th, so I argue that in my brief too, that it was harmless error in this case.
What about Mr. Dean's concerns about the Lake Mary police officer doing the initial arrest in Volusia County for, I guess, a Lake Mary incident?
Well, the trial court found that she had the authority to do that as a citizen's arrest, and she did. There was probable cause for the arrest. Also under Florida statute, which I cited in my brief, you can summon officers from other agencies to assist you in making an arrest, which could have been what they did here. I mean, Volusia County could have taken him to jail. There was probable cause for this arrest. There was nothing wrong with this arrest. There was no ruse involved in this. It was, I mean, as I said in my brief, if she had pulled into that driveway with those 2 kids sitting in the car while they were all there, they still had an obligation to arrest him on that domestic violence charge. So it's our position that, and that would lead into good faith too. I mean, clearly the Lake Mary officer was not trying to get any evidence or do anything, but.
What do you perceive Mr. Dean's believes the remedy should be if the Lake Mary officer, quote, illegally arrested Mr. Toledo?
I don't think it's suppression because, like I said, even if it was illegal, it was done in good faith.
I mean, you don't believe it has anything to do with the subsequent convictions
Correct.
for the murders in Volusia County.
Correct, correct. And they were clearly two separate investigations. I mean, they could not take him into custody on anything in Volusia County at that point in time he filled out a missing persons report. He was a witness at that point in time.
How do you respond to his corpus delicti argument that basically, Mr. Toledo kind of confessed to a lot of things, and absent, that obviously that confession is helpful to the state at trial, but you can't just rely on a confession if you have no corpus delicti of the crime.
Correct.
So he thinks that that's the problem for you guys today. So how do you respond to that?
Well, there's plenty of evidence that these people were murdered. First off, after October 23rd, they were never seen again. There was no activity on any bank accounts, no activity on any credit cards. The children who regularly showed up at school did not go to school. Ms. Suarez, who regularly went to work, did not go to work. The grandmother, Ms. Suarez's mother, lived right around the corner from them, who saw them every day, never saw them again. When the officers showed up to the house, there was odor of cleaning fluid. In the shower, there was like pinkish water that they said looked like, grout, blood in the grout lines. It turned out the daughter, Thalia, her DNA was found in the master bedroom, in the master bathroom. It was found on the mat that he had taken out of her car and disposed of in the dumpster. Her DNA was also on his boot that was recovered from the dumpster.
The daughters? It was the daughters?
Yes.
Yeah, okay.
Yes. Toledo's DNA was found on a garage door opener in a pair of sweatpants that was recovered from the dumpster. Someone across the street heard someone yelling, "Help me, help me, help me," during the night. Two sisters who lived in the home across the street. He was clearly having marital problems, as evidenced through the texts and the behavior that night. So I think there is clearly sufficient evidence that a murder had occurred. I cited probably about 8 cases in my brief where a body was never found, where the courts found evidence similar to that was sufficient to prove.
Does our record here indicate whether the bodies actually were ever found?
They were never found. Oh, okay. They were never found, and as he said in his October 26th interview, you're never going to find them. So, if there are no further questions, I will rely on my brief for the remaining points then.
Questions?
Thank you.
Thank you.
Thank you.
Okay, Mr. Dean, you have 9 minutes, 20 seconds on rebuttal.
Thank you, Your Honor.
Yes, sir.
I want to address that last point first.
Okay.
There's just been this notion that, about the corpus delicti issue, that somehow they've proven murder. They use the term murder over and over and over again like that's the same thing as proving death. It's not. They proved that those people were dead.
Okay. The
According to
criminal
proof.
agency of another is the problem, you think?
Well, the criminal agency of another is something they've never addressed, and they've never addressed any of the elements of murder. That's an intentional killing, premeditated murder. They've never shown by anything else that, with evidence, that it was premeditated murder. The assumption, the trial judge said it, the state said it in their brief, that 2 children were killed, so one of them must have been murdered. The case law is very specific about this, that you can't prove corpus delicti on an assumption. There's never been proof at all that anybody was murdered. There are other ways to die other than murder that are crimes, if you want to call it a crime. There's not any proof of premeditated murder. There's proof of death. I concede that. I have all along. But there is not proof of murder. This is one of those moments where I've been waiting to say to somebody, you've proven death, you haven't proven the elements of murder. And the case law that's cited in the brief for us, it says what crime are they supposed to prove? It's the crime that's charged. It's the elements of the crime that's charged. That's in our brief. They haven't reached premeditated murder on the corpus delicti, and then they totally rely on the confessions to go forward with the convictions. Though that blood evidence, those were pinhead dots of blood. 2 of them were in a bathroom. The expert that testified about how they dropped these pinheads. Nobody testified as to when they were put there. Nobody knew that. Nobody could testify other than whose blood it was when it was put there. The evidence in that bathroom, if you believe that Mr. Toledo actually confessed to the crime, he said that those children were bludgeoned. The testimony from the medical examiner is that one of those child's heads was crushed, that there would have been a lot of bleeding. There was no blood in the grout. There was no blood in the bathtub. There was no blood in the drain of the bathtub. There was no blood in the vacuum cleaner. There was no significant blood anywhere. That evidence, that pinhead dot of blood doesn't match the actual findings that were in the courtroom, and they didn't rely on that scientific evidence. They relied on his statements. Bringing it back, Your Honor, to his statements, when you alluded to him asking to speak to the police after he was denied his rights, he was told he couldn't get a lawyer. They weren't going to bring him one. That wasn't their policy. They couldn't get him one down there. The only lawyer he knew, he had worked on a gang case in which he had testified against the gang he was in a couple of months prior to his arrest in this case. The only lawyer he knew was the statewide prosecutor. He asked for her, and miraculously, against all of their policy, they provided him a lawyer. They provided him her. In one instance, when they're interrogating him, he asked for a lawyer, and Your Honor, they didn't make any bones about it. They knew it. The detective's answer was, when I asked, you knew he wanted a lawyer, and I asked them a bunch of times because I anticipated this exact problem.
Can I just stop you for one
Yes.
second? Didn't he ask for that specific
He did.
attorney
He did.
by name?
He did, and he didn't call her, by the way. They went and got her. He asked the detective if he could get her to come down there, and they brought her there.
But he said Mr. Toledo asked for that
Yes.
specific statewide prosecutor?
Yes.
Not a prosecutor?
No.
Not any other prosecutor?
Her. That's who he knew. He spent time in her office quite a bit with his kids and everything because they had worked on this case closely together. But he was asking for a lawyer. The problem that he had is that they had told him no to begin with. My contention is that while they may have a policy that says we can't bring a lawyer down there, there's no doubt the questioning should have stopped. That's the answer. This notion that he's experienced in the system and he knows the rules and all that, first of all, that's not against the rules for him to know the system. What's against the rules and what's against policy is that when he asked for a lawyer, the questioning continued. He didn't break the rules. This notion that he's got experience, so he must have known what he was doing, so what? I say so what? He asked for a lawyer and they knew he did. They had to stop the questioning. They rely on this policy they supposedly have that they couldn't bring him a lawyer down there because it was against their policy. But everybody knows the remedy for that is to stop questioning him, not to keep questioning him because we can't bring you a lawyer. That's against the law. In Howe versus Fields, that's a Supreme Court case, it's cited at 132 Supreme Court 1181. That case says when Miranda is implicated, the rule should be strictly applied. That's not on Mr. Toledo. That's on the police. Everybody knows the questioning should have stopped. This isn't hard. When I hear good faith, when I hear the state attorney saying, well, they acted in good faith and Your Honor suggested harmless error, this isn't harmless.
Well, they argued harmless error, so
They did argue harmless error.
That's why I asked about it.
But they're not harmless, and I want to make sure I address it. For me, and I mean this in the context that I'm saying it, those are dog whistles for the police screwed up. Please let them get away with it. That's all that happened. Everybody knows what happened here. He asked...
Argue harmless error all the time.
I know.
I wouldn't say that necessarily, but...
But in the brief, the state attorney, the attorney general argued harmless error, and then later on in her brief, she goes back to the tape and lists all the things that were disclosed by Mr. Toledo in his confession. In her own brief, she uses it against him. There's nothing harmless about this. He should have been given his Miranda warnings the first time he was brought into that sheriff's station on October 23rd. He was arrested illegally, but even if he was arrested illegally, he was questioned about what he was arrested for.
What is the remedy? Your view that he was arrested illegally by Lake Mary police officer, so what's the remedy?
Judge, the Phoenix case says that it's suppression. That's the Phoenix case.
Suppress what?
I'm sorry?
Suppress what?
Well, everything that would be gained...
Everything that happened after he was arrested by the Lake Mary Police Department?
Well, when you say suppressed what, it would be on a case-by-case base analysis.
This case.
This case, what happened is that because he was arrested, that put him in the Volusia County Jail on purpose.
Right.
When they got him out of the Volusia County Jail and brought him to the detective's interview room in the sheriff's department, even though they said he was free to leave, he wasn't free to leave for the Lake Mary case. They said they weren't going to question him about it, and then for 2 hours they questioned him about it. Not only did they continue to question him about it, they said, when you want to leave, tell us. You can leave anytime you want. He did want to leave. Once he started getting confronted with the evidence, he asked to leave 3 times. They left him there another hour and collected evidence after he asked to leave. If that doesn't violate Miranda, there's no violation for Miranda. There's not a violation for Miranda because the police say, we can't bring you here. There's no exception to Miranda because the state or the judge believes he's experienced and knows when to ask for an attorney. He gets to ask for an attorney. He did. The police knew he did. Everything that happened after that should be suppressed. The notion that he voluntarily wanted to speak to the police is mitigated by the fact that in his first opportunity to ask for a lawyer, he was told he couldn't have one. The only people he's talking to are the police. They're there all the time speaking to him. I don't think it should be held against him that because he asked for a lawyer, when he wanted one, the first chance he got to ask for one, he didn't get one, and then he talks to the police, it should be held against him. The lawyer he did speak to is the one he knew. And when they said they couldn't provide him a lawyer, they provided her all of a sudden. This is nonsense. This isn't hard. This isn't complicated. The police violated his rights. It's clear as a bell to every law student. I'll tell you sometime.
Well, you ought to watch how you posture things. I mean, when you say stuff
Yes,
like
I
that,
know.
you know, that's,
I
and
told
I'm
you.
speaking as an old trial judge and an appellate
Yes, sir.
judge. When everybody comes up and says, you geniuses, it's so obvious, everybody can figure it out, and if you don't figure it out, there's something wrong with you.
I didn't mean to.
I would just caution anybody who argues about that there are respectively 2 sides to the story.
understand.
And, you know, if we don't buy in, that doesn't mean we haven't actually qualified to go to law school yet. So
I didn't mean to suggest that, and that's why I said it.
coming across.
Well, that's why I said at the very beginning I'm a little bit plain spoken, so please don't hold it against me. That's the way I speak sometimes, and I don't mean to insinuate that you don't know what you're doing. I probably, and I certainly didn't mean to.
I understand you're passionate, but
Just chalk it up to
you know, you need to you know, kind of get big picture that, you know, we take our job serious. We will
I know
look
you
at
do.
things very well, but, you know, to
I understand.
kind of throw it out to us that, you know, anybody can see this, and if you guys don't see it, there's.
I wasn't insinuating that. I was just making an argument. I really wasn't, so.
Okay, all right, fair enough, fair enough.
Thank you, Your Honor.
All right, thank you. I did forget we're going to take a break after the second case, and we'll have coffee in the attorney's lounge. If anybody wants to join us there, that's fine. All right, well argued. Thank you very much, counsel both.